Let's get more now on the High Court citizenship case happening here in Canberra. Kim Rubenstein is a constitutional law expert at the Australian National University. She joins me now live from Canberra. Kim, thanks so much for your time. I know it's been a very busy day for you, so I really appreciate you giving up more of your time for us. Just get your take on what happened and what unfolded in the High Court today.
Yes, certainly. So we heard mainly from the Solicitor General this morning, and what is really interesting is the way the Solicitor General is providing the court with a lot of new material since the last case that was heard before the court on this, the earlier case being Sykes and Cleary. And what the Solicitor General was saying to the court is, I'm providing you some more detailed analysis of the historical evolution of this section, which in his opinion, or in his argument rather, is to suggest that there is a reading down of section 44.1. So you don't read the plain words of any person who is a dual citizen is not entitled to be a Member of Parliament, but rather to look back at the history and in his argument, the history shows that historically in their arguments, that it was only natural-born citizens as opposed to citizens by descent, that this distinction between being a British subject by virtue of being born in territory was quite distinct from being a citizen by virtue of descent from another country, and so that the court should read down these provisions to only being a requirement in terms of voluntariness for those individuals born in the country.
And this would then explain the way in which the Commonwealth has broken up into sort of two categories, those groups of people, where there's a group of five in one and a group of two in another. Does that seem to sort of substantiate this, these arguments by the Solicitor General?
Well, it certainly makes it consistent, but there was a very interesting question from Justice Bell, Virginia Bell, in relation to that historical reality, and she said, well, if we go, if we're wedded to that historical reality, wouldn't that then enable anyone who is a natural-born Australian, we don't use that terminology anymore, it's automatic citizen by birth in Australia, but also happens to also be a citizen of another country by virtue of descent because of their parents or grandparents, wouldn't that historical reading then say that anyone who is a citizen by descent can be allowed to be in Parliament? And the Solicitor General recognised, well, if we were wedded to that position at that time, yes, it would, but they're not actually making that point. He's saying that, in fact, since that time, there has been a recognition, and indeed he recognised that there were citizens by descent at that time, but he's saying now we're at the point where someone in that position, once they know that they are a citizen by descent, needs to take a step to renounce that other citizenship. So there is some form of inconsistency in the philosophy behind that argument, and he's trying to contain it as a historical context for the provision, and as I understood it, he was also saying and is a way to assist in interpreting it for in current times.
If that argument stands, if that historical interpretation is strong enough in order for the court to find that, yes, that is a substantial argument, does it then mean that Section 44 is simply out of date?
That's a really interesting question. I think that it raises some interesting policy questions more broadly than that. Some may say that it's a way of dealing with a multicultural society, and that there are a lot of people who do have citizenship from other countries by virtue of descent, and perhaps that is a more modern interpretation. But the other way is that it then creates an inequality of access to citizenship, in that some individuals who have to take an extra step, which is citizens from other countries first who become Australian citizens, have to take that extra step before entering Parliament, whereas those citizens who have their other citizenship by virtue of descent don't. And so I think that there would be some interesting questions in terms of a policy of an equality of citizenship of entry to Parliament, whereas the current interpretation, according to Sykes and Cleary, where everybody who is a dual citizen has to renounce, is a more egalitarian notion of our democracy. So I think it would again raise questions, which I'm on the public record for having advocated, that we actually really do need to repeal that section and create a legislative framework for thinking about what is more appropriate in today's day and age.
Kim, we're day one of day 3 into this hearing at the High Court. Is 3 days enough?
Well, I certainly think it will be a very full 3 days, because they're quite elaborate arguments that have been put before the court that are now on the record. So I think 3 days should be enough because, of course, the court can look and examine those written arguments. But they will be, I think the next 2 days will be very interesting to see the responses and the way the advocates for the contradictor and the amicus respond to this more narrow interpretation of Section 44.
Kim Rubenstein, great having you and your expertise on our show. Thanks so much.
My pleasure, Kumi.